Good morning, this is your Kelso Report for Tuesday, August 14th, and I'm your host, Clark Kelso. We begin with an environmental law case from the Ninth Circuit today. The United States Bureau of Reclamation is responsible for the operation of the Glen Canyon Dam situated on the Colorado River. And the Fish and Wildlife Service is responsible for the protection of the humpback chub, a fish that exists primarily in the relatively inaccessible canyons of the Colorado River, and that is listed as endangered. About 15 years ago, the Secretary of the Bureau selected a modified low fluctuating flow regime as the dam's specific operating criteria in a NEPA-required record of decision. Since that time, the Bureau has routinely issued annual operating plans, AOPs, consistent with the modified low fluctuating flow regime. The Grand Canyon Trust sued to block the most recent AOP, alleging that the Bureau and Fish and Wildlife had violated the Endangered Species Act, NEPA, and the Administrative Procedure Act. In Grand Canyon Trust v. Bureau of Reclamation, the Ninth Circuit unanimously upheld the District Court's grant of summary judgment in favor of the government, concluding that adoption of the AOP is not the sort of discretionary agency action that is subject to the requirements of the environmental laws. As the Court explained, the Endangered Species Act's consultation and process requirements come into play in this context only when an action results from the exercise of agency discretion. Endangered Species Act consultation requirements do not apply to an action that an agency is required by statute to undertake once certain specified triggering events have occurred. In the case of the AOP, it is required to be nothing more than a description of how the Bureau has operated the dam in the past year and in the upcoming year under the adopted criteria of the modified low fluctuating flow. The Court concluded that adoption of the AOP was a specific non-discretionary act rather than an act involving the exercise of discretion, and so it affirmed dismissal of the environmental claim. Next, an interesting application of Miranda. In People v. Sauceda Contreras, the issue before the California Supreme Court was whether the defendant had clearly invoked his right to remain silent, or whether his initial response was ambiguous enough so police officers could ask the defendant to clarify his response, a clarification which led to incriminating statements by the defendant. The defendant was arrested on suspicion of murdering his former girlfriend after he was found burning her body in a large metal trash can in his backyard. He was transported to the police station and, with the assistance of an officer interpreting for him in Spanish, was apprised that he had a right to remain silent, that anything he said could be used against him in a court of law, that he had a right to the assistance of counsel, and that if he wanted a lawyer and could not afford one, counsel would be appointed for him at no cost. The defendant clearly indicated that he understood each of those rights. When then asked, having in mind these rights that I just read, the detective would like to know if he can speak with you right now. The defendant responded, "If you can bring me a lawyer, that way I can tell you everything that I know, and everything that I need to tell you, and someone to represent me." Seeking clarification, the officer asked the defendant, "Okay, perhaps you didn't understand your rights. What the detective wants to know right now is if you're willing to speak to him right now without a lawyer present." The defendant responded, "Oh, okay, that's fine." The officer told the defendant, "The decision is yours," to which he replied, "Yes." The officer again asked, "It's fine?" The defendant replied, "It's fine." The officer inquired a final time, "Do you want to speak to him right now?" The defendant responded, "Yes." The defendant went on to give a lengthy statement, the portions of which were admitted into evidence at trial. and the jury convicted him of first-degree murder. On these facts, a split panel of the Court of Appeal concluded that the officer should not have attempted to clarify his initial response, but the Supreme Court of California unanimously reversed, finding that the initial response by the defendant was sufficiently ambiguous to justify further clarification of the defendant's intent, and under the totality of the circumstances, the defendant's response is made clear he was willing to speak with the detective at that time without an attorney present. Next, we turn to an interesting application of the doctrine of disentitlement. In re Marriage of Hofer, a marital dissolution action, the trial court had ordered the husband to pay the wife's attorney's fees and costs pursuant to Family Code Section 2030. The husband appealed and contended that the evidence of his financial circumstances was insufficient to support the award. The Second District dismissed the appeal without reaching the merits under the doctrine of disentitlement. Now, the disentitlement doctrine enables an appellate court to stay or dismiss an appeal of a party who has refused to obey the Superior Court's legal orders. It is not a penalty imposed in the manner of a criminal contempt, and is instead an exercise of a court's inherent power to use its processes to induce compliance with a presumptively valid order. The disentitlement doctrine prevents a party from seeking assistance from the court while that party is in an attitude of contempt to legal orders. Well, in this case, the defendant chose not to disclose any evidence of his financial circumstances to the Superior Court, despite 3 separate discovery orders and sanctions. So it's no wonder there was no evidence of his financial condition. He refused to disclose it. According to the Second District, this choice disentitled the husband to his choice to appeal, and he was left with a $200,000 attorney's fees judgment against him. Finally, we have a class arbitration case. In Truly Nolan versus Miranda, several employees had filed a class action against their employer, asserting various violations of California's wage and hour laws. Truly Nolan moved to compel arbitration of the claims under arbitration agreements signed by the plaintiffs, by the parties, and requested that the court order plaintiffs to arbitrate on an individual and not a class basis. The arbitration agreements did not contain any specific provision pertaining to the availability or unavailability of class-wide arbitration. It was totally silent. Now, at the time this case began in the Superior Court, California law took a rather negative view about attempts to limit class action claims in arbitration. But while this case was working its way forward, the law changed significantly, particularly with the United States Supreme Court's decision in AT&T Mobility versus Concepcion, which overruled California law that had specifically targeted waivers of class arbitration as unconscionable. The law now is clear that waivers of class action arbitration are generally enforceable, and that class claims are arbitrable only if the parties have agreed to arbitrate class claims. In light of these changes in the law, the 4th District held in Truly Nolan that the Superior Court had erred in ordering class arbitration pursuant to then existing California law, and the court remanded to the Superior Court to give it an opportunity to determine whether the parties had impliedly agreed to arbitrate class claims, notwithstanding the absence of any express provision agreeing to arbitrate class claims. It'd be very interesting to see what the courts start doing about finding an implied agreement to arbitrate class claims. Seems to me that's going to be contrary to the spirit of the U.S. Supreme Court's directions, but we'll see what the lower courts here in California come up with. That's it for today's Kelso Report. Have a great day in the law.